Just want to reiterate the importance of the Sleepy's case and getting in compliant. I know I still have clients that still aren't punching clocks and things like that. So this is not something you can kick down the street. You're gonna have to take care of it. So next on the agenda is employee labor law issues. Obviously, I'm sure Sleepy's is gonna be part of it. So Jeff Fritz from Fisher Phillips will come up and present that.
Great. Thank you. Hi, everybody. Peter?
Hi, Jeff.
I guess first I need to apologize to Bob. I have a PowerPoint presentation. I know that he has an animosity toward these things, but hey, I guess you don't have to look at me as much. So we do have a PowerPoint presentation. We'll probably run through it relatively briefly and not, kind of get down in some of the weeds ultimately. But thank you, Bob, for addressing Sleepy's. I guess, I'll still walk through, I guess, some of the more finer details as well. Certainly Bob's the expert on the legislative side of things. And I know that Bob and Peter and the organization have been working tirelessly to address this issue, which really is a debacle. I kind of looked it up in the dictionary. In my view, it's akin to something along the lines of this. Ultimately, is let's assume there's a statute that says to the people of the Commonwealth, you need to drive at a reasonable rate of speed on our highways and byways. And let's assume the Department of Labor, the Department of the RMV comes out and says, okay, well, we've determined in our professional judgment that a reasonable rate of speed is 65 miles an hour on the highway. And the public who relies on that agency to tell it what it needs to do or what it can't do says, okay, great, the RMV said we can drive 65. Look, they posted all these signs out there, it says 65 miles an hour, so we're all driving 65 miles an hour except for, say, my grandmother, who's significantly less. And then let's assume a few years later, 3 years later, this issue gets caught up with folks like me in the legal space, and the SJC comes out and says, you know what, sorry, the RMV got it wrong. In our esteemed judgment, a reasonable rate of speed is 55 miles an hour. Okay, great. So the SJC says this. Can we comply with that going forward? Sure. Does it get us there quicker? No, but we can comply with that going forward. But where the real kicker here on Sleepy's, which, frankly pisses me off as somebody who's defending a lot of these cases, is Sleepy's really is akin to the government in essence saying, well, not only do you have to kind of prospectively drive 55, but we had a monitor in your car, obviously, the GPS stuff. So we have a record of all the times that you were going above 55 miles an hour. We're going to send you a bill. Not only for the fines that we've now determined should be imposed, but triple that amount. We're going to multiply those fines by 3, and also you got to pay the attorney's fees. It's absurd. It's ridiculous, but that's what we're dealing with, and that's what we're trying to deal with both prospectively, with Bob's organization, with legislation, and also retroactively on the legislative side and also on the litigation side, which is where I'm dealing with folks. Also going to talk briefly about the U.S. Department of Labor's new overtime rules. Relatively simple and straightforward, but they are an opportunity, number one, to review your pay plans for compliance, but number two, to the extent that you find other issues that maybe you weren't in compliance with that have nothing to do with this, for example, having not made a change with respect to Sleepy's, which everybody should have done. You can try to roll any of these other existing violations, or potential violations into these global changes to potentially dilute the impact on these employees and really, hopefully they ask less questions, right? And the last thing that I'll touch upon briefly, and again, limited space, so I'm going to be jumping mountaintop to mountaintop here, is the paid family medical leave, which I suspect everybody's heard of and is now, has made some decisions and understands the obligations, but we'll jump through them quickly. So just briefly on the history, ultimately, the difference between the big issue here with Sleepy's, well, at least the part of it stems from the fact that under federal law, you need to pay overtime for non-exempt employees on everything, including commissions. Versus Massachusetts law is much different. it actually excludes commissions from the regular rate of pay. So they don't count for purposes of determining overtime. And we have a statute that says, okay, how do you determine overtime? It's 1.5 times the regular rate of pay, but for commission-paid employees, the regular rate of pay is 0 because all their compensation is excluded. So how do we pay these non-exempt employees under Massachusetts law overtime? The question was asked of the Department of Labor Standards, which is they're the experts on this stuff. They're the agency charged with enforcing and interpreting these laws. And in 2003, they issued an opinion letter, which was for everybody to read, including employers, that in essence said that so long as your commissions are sufficient to cover mass minimum wage up to 40 hours, time and a half mass minimum wage above, you're in compliance. Hey, great. We've got guidance. It makes sense, frankly. It allows employers to incentivize their salespeople. It allows them to, in essence, operate consistently under state and federal law, because these guys are exempt under federal law. Federal law has a salesman exemption and a commission-paid exemption. These guys, in essence, are going to be exempt. So we've got this weird kind of dynamic where they're exempt from overtime under federal law, not under state. And this interpretation makes all the sense in the world and allows you folks to operate in a way that benefits both the dealership and the salespeople, to fully incentivize them to do their work. And that's how this operated. It was never challenged. Nothing ever happened with respect to it. We got 6 years later, 2009, they issue another opinion letter. It was centered on, somebody had asked the question, well, what happens if these guys do some other work where we pay them hourly? And it answered that question and reiterated this. A plain reading of the two provisions compels the conclusion that such an employee be paid at least the equivalent of minimum wage, which was $8, and 1.5 times for all hours above it. The equivalent of, these are 100% employees. All this stuff comes from commissions, makes sense. In 2015, there was a change in the statute, in the regulations by, again, DLS is the ones who put this together. And this is what the plaintiff's attorneys harped on to try to suggest that there was a change in the law ultimately. I've read this language probably 1,000 times at this point. It still doesn't make much sense to me. I've spoken with the staff attorney who in essence drafted it at DLS. He, I guess, acknowledges that it doesn't make, it could have been written a lot better. And ultimately the focus is on the second part. It's supposed to be something that deals with what's called the fluctuating work week. There was no intention with respect to DLS to change the way that you pay 100% overtime people with this stuff. None at all. And if it wasn't clear from the language or the other stuff that we know, it's clear from the fact that in 2016 and 2018, the agency issued two topical outlines, okay? These are, I think the first one was 50 pages, the next one was 70 or 80 pages of all this guidance for everybody in Massachusetts, including employers, that reiterated the opinion letters, okay? And it said for 100% commission-paid employees, all you need to do is make sure that the commissions are sufficient to cover. Couldn't be much clearer in my view. But that did stem some cases. There was probably about 15 cases filed by one or two plaintiffs' firms with this novel idea that this language changed the method of payment, that you need to pay separate and apart from commissions this overtime. It doesn't really deal with Sunday, but they made the argument anyway. So So there was a bunch of these cases filed, and eventually one of them found their way to the SJC. The unfortunate piece is we say in the law that bad facts make bad law. This one was a little bit of bad facts because this was just a straight up $125 a day draw on commissions for sleepies. And you can see in essence how it went as far as the class action being filed in state court. It was removed to federal court, and then because it was this unique question of state law, the federal court referred it in essence to the SJC to answer two questions, okay? If 100% commission paid inside sales employees work more than 40 hours, is he or she entitled to additional compensation for overtime when the total comp, in other words, all the commissions, are equal to or greater than what we discussed? And if yes, how do you calculate that? And the second question was the same question, but with respect to Sunday and holiday pay under the archaic Massachusetts blue laws, which are in the process of being phased out, but which also were there were all kinds of problems with the phase-out as well, which is beyond the subject of this presentation, but if you're not paying 1.5, if you're doing the phase-out, be careful because there's potential liability there. And ultimately, the decision is not by any means the model of clarity, and there are parts in the decision that say you can't use commissions to cover minimum wage. Okay, fine. Overtime pay, fine. But the other holdings talk about these things being retroactively allocated. And if and when we have to fight this out in subsequent briefing, we'll be fighting over that language and what it means. It's unclear from the decision what it means. The SJC relied on cases, frankly, that have nothing to do with this, with the case. The case where they got the retroactive language was about an employer who terminated somebody, didn't pay them the vacation pay that they were due at termination, but made gratuitous payments going forward and said, well, yeah, we didn't pay the vacation pay, but we should be able to retroactively allocate these gratuitous payments that we made toward that obligation. And the court said no. So I understand what retroactive allocation means there. Here, I have no clue what it means. There's nothing retroactive about anything that you folks were doing with your commission plans. These were plans that were put in place, presumably upon employment. Here's how we're going to pay you. It was prospective the whole time. So I don't know what that means, and we'll have to fight it out if the retroactive piece doesn't work or if the legislative piece doesn't work. But the court concluded ultimately that they're entitled to this separate and additional payment of 1.5 times mass minimum wage for all hours over 40 and or all hours on a Sunday or holiday. And the way to figure that out is you look at the overtime hours, you look at the Sunday and holiday pay hours, whichever one's greater, you're multiplying it currently by $18 an hour, and that's in essence your exposure. The court recognized that the DLS opinion letters may have misled employers. I mean, I disagree. I think the letters were clear as day, and I think they're correct. But at least they gave us that to kind of latch onto. And they looked at the purposes of the overtime law in making their decision largely, which is to reduce the number of hours of work, encourage the employment of more people, and to compensate employees for working a long work week. So, where are we now? Bob's right, there's been about 80 class actions filed since the decision hit May 8th. We have about 20 of them, something along those lines, and we're fighting it out. Some folks have arbitration agreements. If you have an arbitration agreement, that can help minimize liability because you're doing these as one-offs with individual employees versus on a class basis. But ultimately, we're filing motions to dismiss in a lot of these cases based on the issue of retroactivity. It really gets back to what I led with, which is fine. You want to change, you want to move the goalposts, SJC, we need to comply with it going forward unless and until the legislature, changes things. Fine, great. But it's inherently unfair, unjust to basically pull the rug out of employers for doing, not in essence, but specifically what the government told them they should or could do with respect to 100% paid employees. And not only single liability, but automatic triple damages, attorney's fees, 12% interest, and frankly, there's potential criminal penalties in these statutes. It's absurd. And so we're arguing on motions to dismiss in a lot of these, that this 3-factor test should apply, that this stuff shouldn't be retroactive, and we'll see what happens. I mean, ultimately, one of these cases, I mean, there's 77 of them pending, is going to get up to the SJC more than likely. Once that happens, most of the other litigation probably will get stayed or hit pause until the SJC makes a decision on this issue. And then we'll see what it does. Hopefully they've heard enough of an outcry and reread their decision because, I don't know how many folks in the audience have read it, but it's all over the place. And make the correct, I would argue, decision that, okay, we're going to determine this is what the law says going forward, but it's inherently unfair to dealers and employers generally to tell them that they're going to be penalized significantly to the tune of hundreds of thousands, if not millions of dollars for doing what the government told them they could do. We'll see how that goes, but that's kind of the current state of the litigation. This is just an example of the snowball effect of this stuff. Some folks, I have these conversations with some folks, well, they don't work a lot of overtime, it's only a few hours here, it's only a few hours there. I deal with this on pay plan reviews all the time on various issues. The problem with these laws is the snowball effect of them being brought on a class basis and the automatic triple damages. As you can see here, if we assume 10 employees, and I use the absurd example of 15,000 commissions a month because it just doesn't matter what they're paid in commissions a month, which again is silly. If they work 50 hours a week, that churns through to an exposure of about $850,000. That doesn't include the attorney's fees that you'd be paying somebody like me, the attorney's fees on the other side, which you'd be responsible for, and the 12% interest. So these are significant, significant liabilities. And Bob's absolutely correct that if you haven't made a change since Sleepy's, you absolutely need to do so ASAP, and I would recommend doing a look back at least to the Sleepy's decision and paying whatever it is out before you're sued. If you pay stuff out before you're sued, at the single level, and again, I'm not suggesting you do it before Sleepy's, you may or may not want to, is this 3-year look back. Well, it's a 3-year look back from current date if you haven't been sued, but certainly you want to do that single damages between March 9th and today, because if you get sued, then you're on the hook for treble. But if you pay it, you're off the hook for the treble damages. Can it be fixed? Again, we're looking both retroactively and prospectively, and I think Bob's addressed much of this slide. And I guess the best I can say is I'm working on it from my end, in the individual litigations that I'm dealing with, and I know MSADA is working on it on their end on the legislative side. Hopefully, reasonable minds will prevail here, but you should absolutely review your pay plans and identify these issues. And that's probably enough on Sleepy's that you've heard. Does anybody have any questions on Sleepy's before I leave that subject? Good. So, in the time that I have left, I'm going to address 2 topics. One of them is relatively quick and straightforward. One of them is a lot more nuanced, but I'm not going to get into probably a lot of the nuances, but just hit some of the mountaintops. And the first one here is the U.S. Department of Labor's new rules. Now, this is the Federal Department of Labor. They put together some new overtime rules. You may recall that this exercise had occurred previously toward the end of 2016 under the Obama administration's department, where they had increased the salary basis and made some other changes. That ultimately was enjoined by the Fifth Circuit and then the rest, and it was just kind of put on hold once the Trump administration came in, and they in essence went back to the drawing board. And we now have the results of those efforts, and we can expect these results to be put into place effective January 1st of 2020. So what are the basics? What do they relate to? What do they not relate to? So these are, in essence, related to what's called the white-collar exemptions to federal overtime. And when I say federal overtime, these exemptions, Massachusetts law tracks these exemptions for purposes of the white-collar exemptions. So it concerns your executive exempt employees, administrative employees, if you have them, professional employees. It does, and there's also a bucket called highly compensated, which we'll touch upon briefly. But it doesn't concern, other folks who may be exempt under federal law, such as salespeople, parts counter, mechanics, and others. Let's say the commission paid exemption under federal law. So this is specific to the white collar exemptions. Now, those exemptions are unique with respect to others. There's in essence 2 general parts to them. One is the duties test, which is basically, okay, the employee needs to do certain things, be responsible for certain things to qualify for the exemption. The second test is a salary basis test. The person needs to be paid by a certain method in order to be exempt from federal overtime, that method being the salary basis. Just a quick primer, the executive exemption, that's generally your managers, where their primary duty, again, their main, most important principal duty is managing, they're doing the actual management work of a department or a sub-department thereof. Certainly your general sales managers, folks heading departments. We do see litigation for assistant manager types as to whether or not their primary duty is the management of a department. So if you've got a general sales manager and a couple sales managers, just because they got the word manager in their title doesn't mean they're going to qualify. Person needs to supervise the work of 2 or more full-time employees, and they have to have the authority to hire and fire, or their recommendation afforded significant weight. And if they do all those things or have those responsibilities, they've satisfied the duties test anyway of the executive exemption. The administrative exemption is similar. Their primary duty is the performance of work directly related to the management policies or general business operations. These are the folks who are doing the running of the business, marketing, HR, folks of that nature. The staffing work versus the production work. People who are doing the actual production of the work, selling, let's say, even F&I managers, they're selling a product ultimately. They probably aren't going to qualify, but that's the first prong. The second prong is their primary duty needs to include the exercise of discretion and independent judgment with respect to matters of significance. These are all defined. There's been a whole ton of case law on what that means, but in essence, they can't be, kind of square peg, square hole. They need to be making kind of decisions on their own as to which way to take things. The example I use is the marketing person who says, hey, the dealership says, here's your marketing budget, have at it. Figure out how we're going to market. That's kind of, your archetypal administrative exemption versus a marketing employee who is told, hey, I want you to do this, that, and it's really going to depend on the level of supervision. So that has not changed, and that will not change. The salary basis test is the second general prong. And what does that mean? Well, it doesn't necessarily mean a salary. It certainly would encompass a salary, but what it means in essence is a fixed amount of compensation each pay period on a weekly or less frequent basis that's not reduced by variations on quality or quantity of work. So a guarantee on commissions, for example, of a set amount should qualify the salary basis test. Now, since 2004, that threshold amount has been $455. And it hasn't increased since then. It's been steady at 455. There are certainly limited bases for deductions. I won't walk through them, but you're going to need to be really careful for deducting pay from folks who you're going to claim these exemptions, because improper deductions can jeopardize the exemption. But the threshold, 455. There's a highly compensated exemption, which, you get a total amount of compensation. They need to perform, in essence, one of the duties of one of the other white-collar exemptions, and they need to also be paid on a salary basis. So what's the change that just came out, I think last month in September, that's going to go into effect January 1st, that's going to impact both federal and Massachusetts exemptions? Well, the salary threshold increase is going from $455 to $684 a week, which is significantly less than what it was under the Obama administration's department. I think it was $913. So this is a bit of a more modest increase, but certainly significant. The annual salary increase for the highly compensated folks is up to $107,000, almost $108,000 from $100. And again, that's a more modest. I think under Obama, I think it was $143 or something along those lines. There's this other piece where you can use commissions or other incentives to satisfy 10% of that obligation. So $68.40 anyway. Maybe this is helpful in some industries. I don't know how helpful it is, but they allow that not for the highly compensated, but for the other exemptions. And those are really the major changes. So there's no change to the duties test, and I guess one thing that they do suggest is that you can expect more frequent updates, and by updates, you should assume that means increases in these amounts in more regular intervals. But what do you need to do at this point, given these just were announced last month? They go into effect January 1st. It's a great time to review your pay plans, both with respect to this specifically and generally, and determine, are we paying these folks appropriately currently? And if not, what changes do we need to make? And are we paying these guys, will we be paying these guys appropriately going forward January 1st? Make any changes that you need to make. And again, these are great opportunities. Everybody, whenever I deal with fixes, I do these pay plans, reviews all the time, and folks say, well, how am I going to roll this out? If I tell them we're changing it, they're going to ask why, and what do I tell them? And there's not a great answer to that. Ultimately, you want to do it in such a way as doesn't raise eyebrows, and then these folks go talk to some of the nudniks that are filing all these sleepies cases. And this is a good opportunity to figure out kind of what is my house in order, where isn't it, and how do I roll that into these broader changes so as to minimize or dilute the impact on particular employees asking questions. Any questions about that? Good. A lot of damages if you don't comply. You all know that, right? So the last topic, and again, I'm going to address this pretty briefly, is the paid family medical leave. If you haven't heard about this, you need to talk to me after this and give me a call. I suspect everybody's heard of it. What's the coverage? Well, I won't spend much time on it, but ultimately, beginning in 2021, there will be paid family medical leave for a number of purposes, similar to what we're dealing with under the FMLA, the federal FMLA, which you may or may not be covered under. This you will be covered under, but it's for birth, adoption. It's to deal with medical issues for yourself, for family members. It's to deal with qualifying exigencies associated with military service and the rest. There's kind of a phase in as far as when employees can use it for various purposes, but really we're looking at 2021, and the medical coverage is the same. It's up to 26 weeks total. And the week, they're all different types of weeks. There's intermittent leave allowed for certain parts of the law, but the aggregate leave is 26 weeks. So I know there was a number of purposes there. They all had their different numbers. The total amount for an employee is 26 weeks in a benefit year. So who's a covered individual? What's interesting about this law, and there's a lot of differences between federal law, is they don't have the same kind of eligibility requirements. This is really almost like it's really akin to an additional tax and an additional benefit like unemployment, really. I mean, it's handled exactly the same way as unemployment. And you could have somebody come on board and in day 2 be eligible for FMLA because they've met the financial eligibility requirements going backward in time. What's also interesting about it, unlike the federal law, is these guys could still qualify for paid FMLA under the program up to 26 weeks after their employment's terminated. So, I didn't write it, but that's what the law says, and we'll see how it plays out. These are all great ideas, some less so on paper, but we'll see how they play out ultimately. And obviously between now and then, they're trying to fill the coffers, and we've already started with the contributions, which we'll talk about. With respect to your obligations, putting aside kind of the program itself, once somebody takes the leave, you can't interfere with their rights to take the leave, and you can't retaliate against employees for taking the leave. You have to restore them once they return from the leave to their previous job, or if it's not available, an equivalent position with, in essence, as close to the same pay status, employment benefits, and the rest that you can establish ultimately. There is an exception if you're doing layoffs and these folks are going to be let go anyway. They don't get greater rights than folks like who were there and if they were going to be terminated, except for actually they do, because if they were going to be the only layoff, this law says you can't do it, and so they do get this additional benefit. They have to continue to accrue benefits while they're out, all these benefits. Now, obviously, if they're not working, they're not accruing sick time under the state law. But it can't affect their right to accrue any and all of these benefits or any of the benefits that they have in your policies or under the law. Notice requirements. If you haven't done it yet, you need to do all of these things. Number one, you need to make sure you've got a poster up in your dealership. It needs to be they have a number of different languages, and if you got folks who speak different languages, check the posters, because if 5 or more of your employees speak that language, you need to make sure you got the appropriate ones up. There's a written notice requirement that you need to give to your employees if you haven't. Same language requirements. If you don't give them this notice, there's penalties involved, and you're deemed not to have notified them, and therefore you're subjecting yourself to a potential interference claim. So you want to make sure you've got that buttoned up. The employee is supposed to give you, as the employer, at least 30 days notice for any leave that's foreseeable, or at least as practicable. Sometimes these things are not foreseeable, but for any foreseeable leave, they're required to give you 30 days notice so you can make appropriate adjustments. But if you don't give them proper notice, any of these notice requirements are waived. So the contribution amounts, I'm sure you've all heard this stuff before. We had a delay. That delay was geared largely toward allowing the insurance companies to come up with policies that you can use potentially in lieu of these obligations, so long as they're approved by the Department of Family Medical Leave. And so with that delay, they increased the contribution amount, which is 0.75% of your employees' wages, up to the Social Security limit, which is currently almost $133,000. A portion of that is the employer's responsibility. A portion of that is the employee's responsibility. But if you're under 25 employees, I don't know whether that applies to anybody in the room, the employer doesn't need to pay its portion. But the portion rates are up there. And this will be adjusted each year, I'm sure upwards. They're trying to gauge how much they're going to use of this money going forward. They need to build up their coffers. I don't know whether they're anticipating how much use this program is going to get. Obviously, it's rife for abuse of employees. So we'll have to see how it works out, or doesn't. Again, you can't retaliate against folks. And what's interesting about this law is there's a presumption of retaliation for anybody who experiences an adverse action within 6 months of a leave, right, or the termination of some kind of proceeding. So what does that mean? This law, it's unique on the retaliation side. What this law says is if somebody comes back from leave and a week later punches their boss in the face, and you terminate their employment, there's a presumption against you that exists in the law that says you terminated his employment for exercising rights under this law, that you have to now prove by clear and convincing evidence that wasn't the case. So that the deck is stacked well against you. Now, I would submit that in that instance, with the punch, you can probably satisfy the burden, but the ridiculousness of kind of the presumption is apparent there. So the long and short of it is, if you're going to be terminating somebody's employment or giving them an adverse action within 6 months of their exercising rights under this law, you should think twice. You should consult counsel. Make sure you're on firm footing in what you're doing. Again, violations here can be stiff. All this stuff has this treble damages and everything else, attorney's fees and the rest. So you want to make sure that you're staying on the right side, or as much as you can stay on the right side of these laws as possible. So that's my mountaintop to mountaintop paid FMLA. Anybody have any questions about that? Yep.
With the releases that employees sign at the time of termination, do they still stand, and what's the situation with that? They sign a release for a certain amount of money on termination.
In other words, you terminate their employment. In connection with that, you provide them severance pay in exchange for a release of any and all claims. That likely would not impact their ability to collect. Now it may impact, if they're getting money from a different source, it may impact the amount that they're able to collect, and the amount that they could collect through the state will be less, but it wouldn't necessarily impact their ability to get benefits. But I guess on a good note, maybe, the administration of this whole thing is going to be beyond the employers. You guys, everybody's paying in to this whole fund, and then the Department of Family Medical Leave is the ones who are going to make decisions. Now, we all may think those decisions are right or wrong, or that they shouldn't be, but ultimately that stuff's going to be out of your hands, and you don't need to worry about, there's no direct correlation between whether they get benefits and how much you pay. Right? Now, obviously, if we get a lot of folks who are getting lots of benefits over a period of time, everybody's premium is going to increase. But there isn't going to be a one-to-one kind of direct correlation to you, like maybe there is in unemployment, where there's kind of the premiums, that are impacted. Yep.
Wouldn't the F&I managers fall into the overtime exemption?
Right. Yeah, so the F&I managers, depends on how they're paid, okay? The F&I managers generally are not going to qualify for the executive, for any of those white-collar exemptions. They're not managing people, so they're not the executives. If we had to argue it, I'd try to squeeze them in on the administrative, but they're really not doing the staff-type work. They're really selling a product, and so it's a tougher squeeze. So they're not going to qualify for any of those exemptions. Depending on how they're paid, they're usually paid on commissions, largely. They will then probably qualify for the 7I exemption under federal law, the commission paid or inside sales exemption, okay? Now, previously, before Sleepy's, if they're 100% commission paid employees, which many of them were, those opinion letters would suggest that, okay, well, so long as their commissions are sufficient to cover mass minimum wage and 1.5 times for everything over 40, they're good. And these folks are usually well compensated, the F&I managers. After Sleepy's, you know, I think that the Sleepy's decision would impact or apply to F&I managers, arguably, just like they do the salespeople, or just like they do service advisors, frankly, if they're paid on 100% commission paid employee basis. So the long and short is the F&I managers are going to probably fall into that unique category of exempt under federal law, under the commission paid, but non-exempt under state law, and then under Sleepy's entitled to separate pay, regardless of how much they're paid. Separate pay in addition to and separate from their commissions of currently $18 an hour for all hours over 40.
The notices that we handed out for the mass FMLA.
Yep.
On an ongoing basis, should all new hires should get that notice?
Yep. Yep, everybody coming in should get that notice as part of their orientation packet. If they refuse to sign it, then you're supposed to have them sign something saying they refuse to sign it. The law says this, they decided this was enough of a problem that they needed to put it in there. If they refuse to sign that, the law doesn't say. I've had one person call me and say they refuse to sign the notice and they refuse to sign the document saying they refuse to sign the notice. What should I do? And I said, well, this person sounds lovely. But you should mark down that they refuse to sign both, and then do your deductions. I mean, they don't get to opt out of the program, okay? Again, this is like insurance. This is like unemployment comp, right? They don't get to opt out. So if they want to be jerks and not acknowledge this stuff, or they acknowledge, I mean, all it is you giving them notice. And if they're going to be jerks about it and not sign it, you mark that down and you do what you're going to do with them. You know, they don't get to opt out. So there are notice requirements. There's not that same necessary. So there's a general notice posting, and then there's certain notice requirements that go into effect when either somebody requests leave or somebody is in a position that a reasonable employer, let's say, would say, hey, maybe this person needs leave. And there's 3 levels of kind of notification that you give. There's an eligibility notice initially, then you have to give notice of their rights and responsibilities, and these are all within certain time frames. And then the last one is a designation notice, which says whether they qualify. So it's different. There are notice requirements, yes, but they're different. But the federal law only applies to folks who have 75 or more employees in a 50-mile radius, and only their employees who have been there for 12 months and have worked at least 1,250 hours, preceding that are eligible. So, yep.
If they don't sign the notice, can you make that a condition of employment? That you have to sign, you have to be in compliance and sign all the notices?
Yeah, I suppose. I mean, it's that sort of activity is almost like just a little too wrapped up in it that, I don't know. I don't want to buy a lawsuit of somebody claiming that they engaged in some kind of protected, I don't think it's protected, but could you let's put it this way. There's
Not terminate, but just not make it a condition of employment.
and not hire them.
Right, not hire.
Yeah. I don't see why not. Again, if I'm going to pick a battle, I might pick a different one, just because it's wrapped up in the law and it just gets, these folks come up with all sorts of crazy and ingenious ways to try to bilk money out of the folks in this room. So I wouldn't try to give them any leverage on that. Say, okay, but yeah, look, it's not a great way to start your employment, to just be a jerk about something stupid. But any other questions? All right, well, thank you so much. Appreciate you having me.